Anyway, since we seem to be out of witnesses, I thought I'd drink a little.
And Rob.
Hey, Rob.
Coming to you. I'm doing well. It's Wednesday afternoon. We were doing these things on Friday, and we've decided maybe Wednesday's a better day.
So at least this week. Yeah.
Yeah. And Tyler's drinking whiskey sour.
Cheers.
And Rob's drinking straight Jack Daniels with a cool ice cube making cup thing.
That was cool.
Nice. Elixir of the gods, as it were. So today we're going to talk about how not to share your shit.
All right.
Colloquially. Less caustically, how to protect your interests.
All right.
In the event of a relationship breakdown. Brought to you by Rob and Tyler. So you wanted to talk about, I guess, what we call domestic contracts, prenuptial agreements, cohabitation agreements, antenuptial agreements. Basically, written agreements that talk about protecting your interests in certain assets from division to some degree in the event of a relationship breakdown, or at least mapping out with some clarity how that division will take place. Is that kind of, do you think that's a fair summary of?
Pretty good way of talking about it. I mean, to make it simple, basically you can contract before or even during the relationship, but prior to the breakdown, or actually even during the breakdown, you can just contract how you want to divide stuff. But probably the later you get in that relationship or the closer to a breakdown, the more somebody might be incentivized to say, no, I'm not going to contract at this point. I'd rather rely on the default. And there is a default. The default is the legislation. There's some law out there that talks about how we divide assets in the event of a relationship breakdown.
And most of the time when we're talking about domestic contracts, we're talking about pre-relationship or pre-cohabitation agreements of some kind, whether it's before a marriage or before cohabitation. Because once you're together, the incentive for the other party that may be in a lesser financial position to agree to that is kind of out the window to some degree.
Right.
Unless you want to throw them out of the house first year into the relationship, which I've told clients to do, by the way.
You know, the law is a funny thing, and it puts us in a tough spot that we got to give some tough advice sometimes.
So tell me, because I usually drone on these things, so I'll defer to you today. To begin with, should everybody have a prenup? What do you think?
Yeah, if you have more assets or income than the person that you are going to cohabitate or marry with, you should have a prenup. If you have less income or less assets and you intend to probably not have more, might not be to your benefit. Although you can contract whatever you want. So yeah, if you've got some assets and some income, you should definitely be doing it. Or if you think you're going to acquire assets or income, you should be doing it. So if life is going to go the way you want it to go, it's a good idea to have one.
All right. So then 2 questions. What exactly do you need the agreement for? What's the point of it that you're saying, if you have more, you should get an agreement? So what are you trying to do with the agreement?
So what we're trying to do is we're trying to avoid a legislated outcome, right? So the court or there's legislation, the government has legislation that says, here's what's going to happen when you break down, when your relationship breaks down. And basically the way that works is any income or assets that you've generated during the relationship, it's going to be divisible between the parties, and the basic assumption is going to be on a 50-50 split. And there's some reasons we might not do 50-50, but that's kind of the general take on how things work. And so what you might want to do is you might want to say, hold on a second, I've got this great business or RRSP or investment, and I don't want to share half of it, and I don't want to share half of whatever it grows, whatever accumulation I get during the relationship. So if you've got some assets or income, that's why you want to do it. Yeah.
Okay, so you're talking about 2 things. You're talking about income and assets. So let's differentiate those. With the income, your spouse is not necessarily entitled to half or even a portion of your income, correct?
Yeah, not necessarily. So that's kind of the issue about spousal support or alimony, and maybe that's the other side. Maybe we don't need to investigate that today. That's sort of the other side of it, that you can protect yourself, or one way or another, you can protect yourself. Yeah.
And it's probably worth maybe mentioning, and we'll kind of let that go, but your prenup or your cohab, to the extent that you do have agreements dealing with alimony, they're not necessarily enforceable by a court.
Right. Yeah. Courts will throw those out for a number of reasons, and it happens. Yeah.
Okay.
Exactly.
So
Yeah.
let's concentrate on, I guess, what we call a property agreement.
Sure. Yeah.
So you're saying, okay, I'm coming into a relationship, I've got some stuff. What does a typical agreement say about that? What do you want in that contract?
So most typically what we'll have in those contracts is that each party is going to keep whatever is in their sole name throughout the relationship and when it breaks down, and anything that's in joint names would be equally divisible. So that's probably the most common instruction I'll get to draft one of these things. And so the idea behind it is, okay, you come into the relationship with certain assets. If that relationship doesn't work out, you'll go out of it with those assets and anything else that you accumulate in your own sole name going forward. And then hey, if you put that in joint names, boom, that's something we're going to share 50-50 or whatever basis you want to agree on. So that's the most typical way the most typical instruction I get to draft these things. And sometimes we'll do something different, right? We'll say, okay, the more wealthy will pay to the less wealthy a certain amount upon breakdown, just so that they feel like, oh, they're taken care of if that relationship breaks down as well. So you can do what you want, but that's the most typical instruction I get.
Okay. So now let's take the flip side. So new spouse who's on the lower end of the economic spectrum comes to see you and says, typically the woman, but not necessarily, my partner wants me to sign this, giving up any claim in the value of his house or her business. Should I sign it? What do you tell that person?
I think my advice would be no, don't sign that. Go find somebody else who doesn't want to make you sign it, who's got just as much money. When it is from sort of an economic standpoint, that would probably be to your advantage. Now, if you want to be in that relationship and you love that person and that's what you're going to do, at least I can give the advice and say, here's what you're giving up. The assumption would be you'd be entitled to half of the growth on that asset throughout the relationship. So if that's what you want to give up, at least that's what you're giving up, and that's your right to do that. But that's the right you're going to exercise to be in that relationship. And there's people out there who wouldn't probably make you sign that. And I get lots of people who come to see me, of course, who don't have these, and didn't protect their assets.
And you made a comment about growth, and so I think it's interesting to differentiate between the value today and the value tomorrow.
And I kind of touched on this, so let me be really specific about it. So the way that we typically, the legislation typically will say that assets should be divided is anything accumulated during the relationship would be divided presumptively on a 50-50 basis between the partners when the relationship breaks down. When I say that it's accumulated during the relationship, that includes the growth on assets that existed prior to or as of the date of the relationship.
Okay. So, so when I do these agreements, you're typically at least protecting the present day value, right? And even if that's all you do, at least you've crystallized an acknowledgement of what that exemption is, or that part is that you're not going to share. Because that's also often an argument, because people don't value homes the day they get married. Right. So you fix by agreement, the equity I have in the house is $126,000. And when we leave, I get a $226,000 off the top. So even if the future value is still shareable, that agreement at least protects present value at the date of marriage.
And so the reason that's valuable is because people will fight over what that value was or whether there was value at that time, right? Because otherwise it would be exempt. It wouldn't be something that would be shareable between them. But the reason that you would stipulate that in agreement is because, well, at least then you know what that value is, right? Yeah.
Now, how often do you do agreements, and I've done these, where it's not just the value today, but it's the value forever that will not be shared?
Yeah, that's, I think most of the time is the instruction I get. Yeah.
Okay. So I've got a company that currently is worth $500,000. If 10 years from now it's worth double that, I don't want to share that asset. That's
Right, exactly.
not an atypical agreement.
No, exactly. That would be pretty typical.
Okay. Now, do you ever do anything to push back on that for the spouse who's signing?
Oh, yeah. So then I talk to the spouse who's signing and say, look, what are you giving up to be in this relationship? Are you giving up a job? Are you giving up your family connections? Are you moving? Is there some sort of economic or emotional loss or something? What are you giving up to be in this relationship? And they'll, people are self-interested. They'll come up with things, right? They do feel like, yeah, they're giving up something to be in that partnership too. And so then we got to say, well, what's that worth to you? Let's do some pushback and let's put a number in there that's worth to you, or a percent of something that's worth to you. So at least if you were to leave that relationship, and let's say it's a 5-year relationship or a 20-year relationship, you leave that relationship as an elderly person, you want to make sure, okay, you're not just living there and not accumulating anything and not having an income or whatever, and you leave with nothing and you're destitute. You want to make sure that you're left with some security too, right?
Okay. So the pushback that I've exerted that is sometimes negotiable, and I've agreed to it in some cases when I'm acting for the person that's trying to protect their property, is something like you get 0 if this relationship doesn't last more than 5 years. No increase of value.
Okay.
From 5 to 10 years, you get 10%. And then so you have this kind of rolling scale, so that if you get to a point where you've been together 50 years and you're both in your 80s, maybe it's not unreasonable at that point that she is going to get half the increased value, and you basically agree to share future value for a lengthy relationship.
Okay, now I've never done that, and I love it. I think that's really interesting. The thing that I think, the issue that I think creates is, what do you do if the sliding scale is somewhere between a 9 and a 10-year mark, and they're at 9.5, and the relationship's intolerable, and there's been some sort of violence or something?
Yeah.
Is someone made to, oh, okay, well, I'm gonna make sure this thing lasts, or does that push someone over the edge and say, I gotta make sure this thing ends really quick?
Yeah.
That's interesting. Yeah,
I mean, they both have the right? So they're adults. Okay, I'm in 9 years, 363 days, and I'm going to increase 10%. Get out right now.
Yeah.
Or I'm not going anywhere for 3 days, right?
Exactly.
I mean, you could, in theory, get in that, but to me, it's a discussion. It's a reasonable discussion, because if you're in your 20s and you marry a guy or a girl, and things don't work out for 5 years, you really haven't lost a lot.
Yeah,
The potential of finding a career again, or a better mate or something, is a fairly reasonable assumption. If you're 75 years old and you've been with your spouse, for your partner, for 50 years, the odds of you recovering from the commitment in that relationship financially is dismal. So at that point, I can be a little understanding from the point of view of the property holder, if we'll call it that maybe you should be entitled to a little something if we make it that far. And it's always negotiable when that kicks in and how much it kicks in. So that's
sliding scale. Is that something you recommend typically to your clients?
I would recommend it to the person with the weaker financial position.
Sure. Okay, cool. Yeah, I like that.
I'll say, well, first of all, I wouldn't sign it, because this guy, usually it's a guy, is trying to put $1 on your relationship. And if he really loved you, he wouldn't make you sign the agreement. Right?
Right.
Now, if I'm on for the guy,
totally different.
If she really loved you, she would just sign it. She's not seeing you as a paycheck. So your advice for your own client is disparate depending on who they are. But I'll say, no, it's not necessarily unreasonable that he won't share the farm with you if you have a 5-year relationship. But if it's a 45-year relationship, you've given a lot to that relationship now, and now we're going to have to negotiate some recognition either by way of alimony or property or both. So that's kind of the quid pro quo. Now, the other thing, and I'm curious what your take on this is what you hear is, well, these agreements are just a recipe to ruin a marriage. So
you want to talk about that?
We shouldn't have these agreements for people that love each other. What do you say to that?
As a lawyer?
Yeah, as a human being.
As a lawyer, as a human being, that's different. All right, so as a lawyer, I say this. I say these agreements can take the pressure off a relationship. You don't have to worry about protecting your assets. You don't have to worry about what would happen to me if, what would happen to my assets if, what about this inheritance, what about, you don't have to worry about any of that. We can deal with that now, and then you can go live your life, have your holidays, kids, whatever you want to do, takes the pressure off. And that's maybe a nicer way of looking at these things.
Yeah, that's a good point. You know what? 35 years, I've never thought of that, but I think that's a good point. It's something I'll include in my repertoire a little bit.
I like it. Yeah, I like that outlook on the agreements for sure. Yeah, so I guess that's what I would say. I guess that's kind of what I say. It offers security on both sides. Justice is a tough thing. You don't want to pay a bunch of lawyers a whole bunch of money the breakdown of the relationship to fight over the assets that should be yours anyways, not the lawyers. So pay a little bit now, and that's going to be a cheap insurance policy to make sure that things can go smoothly if anything ever happened to the relationship. So that's kind of a benefit. And of course, this not just the money that you pay to fight, but the stress and the time is horrible. So there's some clear benefits to having it for sure.
Cool.
I don't like the idea of entering into a relationship presupposing that it could break down, but the reality is it can break down, and the reality is oftentimes they do break down. So
well, the reality is
not bad to deal with reality.
It's almost even odds, right?
That's right. Yeah, almost even.
It's almost 50-50. So if and it's funny that there's one of my favorite comedians, Bill Burr, has got a bit where he talks about this, and he says, if I told you there was a 50% chance that when you jump out of an airplane, that chute wasn't going to open, do you think anyone would go parachuting? No. But everybody going into a marriage, there's a 50% chance they're going to lose their shit. And they're just like, okay, no problem. We'll do that, right?
Yeah, I love her. Why not?
So that's that's the reality of that. So that's what I say is, well, she says it's going to ruin a relationship. Well, there's a 50% chance you're going to get divorced anyway.
Yeah.
Right. And so better an ounce of prevention than a pound of cure at the back end.
Yeah, that's a good way of putting it. Yeah.
Now, are there ever, and I'd be curious of this because I've done this, are there ever times that you insist virtually that a client get a prenup and tell them to insist with their spouse?
Yes. Yeah, definitely. So repeat clients, if they've seen me a time or two, let's get a prenup in place. Let's not fight about spousal support or property ever again. Let's just get that in place. So if you're a repeat client, I'm going to tell you better get that in place for anybody else who's moving in or out of your house. You're moving in and out of someone else's house. If you've got some particular wealth coming,
and so they tell you, I drafted the cohab agreement, and my wife and her child of a previous relationship has already been living with me for a year. She refuses to sign it. What do I do?
1 year?
Yeah.
Yeah, she's got to move out.
Yeah. Do you tell the client that?
Yes.
And do they listen to you?
No. But they come back. I make a lot of money off of them.
Yeah. I've had 2 or 3 files where the 2 of them, I think, were farms and one was a business. And I said, you need to tell her she has to leave. I had one client do it, actually.
Yeah. Wow. Okay.
I had one specific client that didn't, and then came back to see me 10 years later and said, should have listened to you. The problem is, we haven't even touched on this, but in that case, she had a child of a previous relationship.
Yeah.
Well, within a year or two, you're what's called in loco parentis, which means now you have a support obligation for her child, even if it's not yours.
And
So not
even if the
only,
bio dad is paying or bio
yeah,
mom.
so not only do you have the issue that now she's going to share in the increased value of your business, but you've got a potential child support on your hands for someone else's child.
Which you may or may not get to see.
Yeah.
Yeah.
And the ones I really lean on, and I've written on some papers for some periodicals. If you have a farm or ranch and you're going into a marriage and you own land, do not go ahead with that relationship without a prenup. Like it's virtually, you can't do it. And the reason more than any other business, in my opinion, is when you value farms and ranches, they never cash flow. They never cash flow. Maybe if they have a significant contract, but your general, grain farmer, rancher, their land is worth more if it's liquidated than as a business enterprise. And the problem with that is the increased value of the land, if you have to share that with your spouse or your partner, you may not be able to borrow money to pay that out, which means you're actually going to lose that dirt you had before you met her.
You got to sell it. Yeah.
You got to sell it. And if your farm is struggling a little bit, and they do from time to time, you basically lose your business because you didn't insist on protecting your land base. So those are the ones where I get very direct with my clients and say, look, dude, you can't risk this. There's a 50% chance this thing won't work out. That's just the reality. And there's a high probability your land's going up in value.
Mm-hmm.
And you may not be able to borrow your way out of a settlement. And so you could end up losing the farm. So if she doesn't want to sign it, go find another partner.
Yeah, that's a tough piece of advice to give. But the truth is that's our system. That's how it works. And that's the advice we have to give sometimes.
That's it.
Yeah. Yeah.
So now we're going to shift gears a little bit. So we talk about agreements. That's what you want to talk about. I want to talk about something very similar, but it's about exemptions.
Oh, I see.
And we sort of touched on that.
Mm-hmm.
And it shouldn't take too long, but I think it's important. Exemptions are things you don't have to share when you don't have an agreement. So under Alberta property law, now the Family Law Act, or the Family Property Act.
Property Act, yeah.
The presumption is everything you have is this pile of crap and you cut it down the middle and share it 50-50. That's the presumption.
Yeah.
But there's certain things you get to take out of that pile off the top before you split it. And those things are the value of the asset at the date of the commencement of the relationship, not the present value, but the value then, as long as you can trace it to something you have now.
Mm-hmm.
So if you have $50,000 in the bank and you spend it on your honeymoon, it's gone. If you have $50,000 in the bank and it's still there 20 years from now, that's exempt. Take it off the top. $50,000 in the bank, you put it into a new house in your name alone, and we'll touch on that. $50,000 off the top of the house is yours alone. The other class of exemption, inheritances or gifts. During the relationship, mom dies, dad gives you a gift. To you alone, the value of that at the date you get it is exempt. You don't have to share it later, as long as you can trace it to an asset. Thirdly, proceeds of an insurance settlement or lawsuit not relating to loss of property, typically an injury. Those funds as well, exempt if you can trace it to something of today. Now, the one thing that I really wanted to talk about, because I keep seeing this and it irritates the shit out of me. You get married, you have a house before you get married. It's got equity in it, $50,000. And your wife wants a new house and you say, okay, let's go buy another house. And you go to your idiot real estate lawyer, not Alan Denbach, because he knows better.
Yeah, he does know better.
But you go to your idiot real estate lawyer on the new purchase, and the mortgage instructions come through and they're in the joint names of the husband and the wife. And the husband and the wife look at the lawyer, who's the realtor,
Oh,
state lawyer, and they say,
it's stressing me out.
what's the difference between joint title or, what does joint title mean? And the idiot real estate lawyer says, well, that just means there's a right of survivorship so that if one of you dies, the other person gets the house. Oh, okay. And they sign it. And then what happens is 20 years later, they get divorced and they come to see me. And the husband says, oh, well, I had $50,000 in my house the day I got married, but then we sold it and bought a new house. And I go, did you put that in joint names? And they go, yes. I say, you just lost half your exemption. There's a case called Harrower in Alberta, Court of Appeal. This says there's a presumption of gift. You lose half. And they go, but my real estate lawyer never told me that. And I say, now you need to sue your real estate lawyer because he's an idiot. And he should know this.
And
it's very basic.
I hate telling a client they have to sue a lawyer, but that's probably the number one recommendation. That's the number one time that I have to tell my client.
Oh, it drives me crazy.
Yeah, that's a huge problem.
And it is uncomfortable. I've done these, because I used to do a shitload of real estate, and I still do a little bit. So people come in to you and they want to sign the agreement. They're buying the new house, and they're all excited.
And they're excited and happy, and they're a couple, and they're gonna have a kid.
And I say to the parties, where did the down payment come from? And sometimes it's, oh, well, I sold my house, and that money came from it. Oh, did you have this before you were together? Yes. Okay. Well, this is awkward because I'm acting for both of you, and so I'm in a conflict. But
is that a home phone? Do you have a home phone?
Yes.
That's so weird. I've never had a home phone.
Yeah, it's the phone that is used for
surveys,
telemarketers,
CRA scams.
Yeah. Right.
I've never had a home phone. Well, when I was a kid, my parents did. I never had that.
Yeah, well, I'm a little older than you. So anyway, where was I?
You were saying,
oh yeah.
I represent both of you, but it's awkward. I got to tell you.
Here's the reality: the effect of putting this in joint names is the person with the exemption is going to lose half their exemption, unless the two of you affirm that that's not your intention, and specifically, unless the exemption holder asserts that is not his intention.
Exactly.
And so I've actually had. I've done short little agreements where I've sent the non-exemption holder and the exemption holder out for independent legal on a simple contract saying it is not my intention to lose my exemption, but I'm very happy about the right of survivorship.
Yeah, okay, that's good, yeah.
Right? So if I die, my wife gets the house, but if we divorce, my full exemption's still here.
Yeah.
Now the reality is she doesn't even have to agree to it, right? So if she goes, I'm not signing that, well, you sign an affirmative declaration that the reason I'm putting this in joint names is solely for estate planning purposes and is not to release my exemption. Probably, in my opinion, that would hold up. But you need to do something like that. And the person doing the real estate transaction needs to advise that that's the effect of putting something in joint names.
And I think the Law Society has kind of come down on real estate lawyers a little bit, or not come down on, but they've sort of provided a little bit of guidance last year about make sure you know where that source is, the source of the down payment is coming from. And they were doing it as an aspect of fraud prevention. But the truth is that now all of a sudden, maybe these real estate lawyers get the idea, oh, okay, yeah, maybe there's some exemption issues.
Yeah. So, now, the other weird one is, well, the down payment's a gift from my parents.
Oh, who did they gift the money to?
And is that a gift to you or a gift to the two of you? Right? And that makes for an interesting conversation.
Yeah,
if it's a gift to me, I say, well, you need to get a gift letter from your parents affirming that intent.
Yeah.
Because if things don't work out 20 years from now, them coming to court saying, well, I only intended to give this to my daughter isn't going to carry any weight. And I've actually run that trial and had the judge shake his head and go, yeah, good effort. In the absence of some confirmation in writing at the time, the house is in joint names, I presume that the gift was intended to be joint.
I had a hearing scheduled. I don't know if it was a summary trial or a trial, but I had some sort of hearing scheduled, and that was the issue. And the other side produced a wedding card, like a card from the wedding as a gift. And it was addressed to both of them with a gift inside. And that was it. I was like, all right, give it up. That's not worth fighting over.
Well, I got a file right now with another lawyer that they're trying to say there was a gift to the husband alone by virtue of a sale for much less than market value. The problem is the sale agreement was with the husband and the wife jointly.
That's a problem. That's a big problem.
So I'll run that to trial all day long. But anyway, so exemptions are those things that we talked about, the value at that day, not the increased value. That's subject to being shared. But if you want to protect your exemption, you got to trace it. So I've had cases where I had one really, it was really unfair, but this is what happened. The wife had 50 grand and the husband had 50 grand. She spent all her money on the marriage and he spent the money on the new house. So the 50,000 is, placemats and dinners and drinks at the wedding ceremony. And his 50,000 was still protected in the new house, or at least half of it was.
Oh,
so you got to be aware of how exemptions work. You have to trace them. If they get into joint names, you're going to lose half of them. And it's something worth thinking about. And if your parents want to give you a gift, make sure it's a gift to you alone. And my advice is, even if you think the husband or the wife are the salt of the earth, make it a gift to your kid, because there's a 43% chance things aren't going to work out. And you're going to kick yourself in the ass if you didn't call that a gift to your daughter or your son.
yeah.
It doesn't take you much to say, no, this is an advance on my daughter's inheritance or my son's inheritance, and it's intended to be gifted to them alone, even though I know it's going to go into a joint house. Or better yet, a house in their name alone, but
Right.
there it is. The other thing I've told people to do, which is similar but not exactly the same, is instead of giving your child down payment, loan it to them with interest, payable on demand. And then what happens is you loan your daughter $50,000 plus interest at 7% per annum, due on demand.
Yeah.
If the marriage works out fine, you can forgive that 30 years from now or in your will. If it doesn't work out, well, before the husband gets his chunk of the half, they got to pay you up your 50 grand plus the interest. And that's another way to kind of protect your child's share of equity in a home.
Yeah, that's not bad.
Now, it's got to be commercially reasonable. So if you called the interest 132% per annum, it's probably not going to, it's criminal, first of all, but
I was going to say, there's also some criminal issues there, but yeah.
it's not going to work. But if it's, it's somewhere between a credit card and a commercial bank rate, and I'll use numbers like 7 or 8%.
Yeah.
It's not just the 50 grand, but 50 grand over 10 years at 8%. It's a chunk of money.
That's right.
You're going to be able to carve off, and then you could always gift that back to your daughter or your son later. So those are a couple of things you can do.
Yeah.
And it's a little cynical. All the stuff we're talking about is a little bit cynical, but particularly for, talking about farms, they can be soul crushing, business ending, results if you don't take some affirmative step to protect yourself.
This is coming from, it's cynical, but this is coming from two guys who see a wide array of people coming into their office. I got people coming in saying, I knew on my honeymoon that this was a mistake and we were going to break up. I got people who say, I've been married for 40, 50 years sometimes. We just bought a house together, or we are just selling a house and are about to buy a new property and relocate and go on a holiday that we have planned. I didn't see this coming at all. So it might sound cynical, and it is cynical, but that's, I guess, the point, because that's what we see. So that's the advice we give.
Yeah. And the courts, they are unpredictable, unclear, uncertain, but the law is relatively generous.
Yeah.
In terms of alimony and division of assets. So you got to protect yourself a little bit. So that's the rule for today, right? It's like buying house insurance. Nobody thinks their house is going to burn down until it burns down.
Here's the difference, though. I charge, what do we charge for a separation agreement? I mean, we charge very little, really,
Yeah.
comparatively,
Call
for
it
an
a couple
agreement.
grand.
Yeah, call it a couple grand. An insurance policy, you're going to pay $200-300 a month for almost ever. Man,
Yeah.
that's a good investment. Get an agreement.
Yeah, think about that. My wife and I are just
Holy
talking
cow.
about that. We're paying $360 a month house insurance,
Let it
$4,000
burn.
a year. 10 years is $40,000.
Yeah, let it burn. What are those books in the background
Yeah.
worth?
What am I?
Just
What
let
am
it
I?
burn.
58 years old. None of my houses have burned down. Right? If I've been paying house insurance off and on for 40 years, holy shitness, right?
Right? Yeah, exactly.
Now you still do it, right? Because I'd rather have it and not need it than need it and not have it. But when you go to somebody, particularly a rancher, they're sitting on $5 million worth of farmland, ranch land. It's like, yeah, you probably should get yourself a prenup. It's
For
going to cost you
$2,000
$2 or
or
$3
whatever.
grand. Oh, that's too expensive. Okay, you
Well,
pay
that's
me
stupid.
now. I'd much rather. Now, here's the only other thing, and I got to say this. People should understand. You do these agreements, right? And you spend your $2,500 or whatever, $2,000, and you get separated 20 years from now. And what happens, Tyler? Does your wife go, "Oh, okay, I guess I'll take my 50% of what's left"? Is that usually what happens?
No, they file a claim and try and negotiate and try and get a little more and a little of that. And they need spousal support, of course. And
Yeah. What do they say? What do they say?
they say that the deal wasn't fair at the time. They didn't get proper advice, or they didn't know what they were getting into, or they didn't know how much you were worth, or they didn't know how much you were going to be worth.
Yeah. So, one of the
name
things you got to do, and you got to disclose everything, right?
Yeah, just put your
The
cards
Supreme
on the
Court of
table. This is what I'm
Canada
worth.
has
Yeah,
been extremely
very
aggressive about that, saying, if there's an argument that your wife didn't know what she was doing, and again, without being sexist, it's usually the wife.
Yeah.
We may not support the agreement if there's not been full disclosure, if there's been oppression. But even in the face of that, I've had files. I had one file. We had 3 agreements:
Oh yeah, I remember that.
prenup and 2 anti-nups.
I
Right?
remember that. Yeah.
And no, we want to go to trial. So here's what
Yeah, I
happens,
remember
right? You bring a summary dismissal application saying, look, not only do I have 1 agreement, I've got 3 agreements where she says, this is all I get. And do you think the court's going to give you a summary judgment saying, no, you had this agreement. This doesn't need to go to trial. No, they will almost never do that. So now you're looking at 2 or 3 weeks of trial. And what do you say to your client? Can you say to your client, I guarantee you these agreements are going to be upheld?
Nope.
No. You're going to say, you know what? Family law is ultimately a court of equity. And if some judge doesn't like this agreement, doesn't like how you negotiated it, they may throw it out.
Okay, so does that mean people shouldn't have one?
Well, no, because what's going to happen is, to use theoretical numbers, client's worth $50 million. If there's no agreement, he's going to pay $25 million. We can get rid of her for $3 million, even though she's only entitled to 1.5 under the agreement.
Yeah,
you
pay
do.
that out. Yeah, you pay it out.
You pay her the $3 million, right? Because
Yeah.
you can't take the risk. You can't.
There's
And that's
the trial, then there's the risk.
and so that's kind of the bullshit of it. I mean,
isn't it?
if you have a reasonable agreement negotiated and you've got independent legal, and part of the thing under the Family Property Act is you have to have a certificate of independent legal advice by a separate lawyer who affirms they've advised you as to all your rights. To me, as soon as that shows up, you're done. Now, if you've got some problem with your lawyer, go ahead and sue your lawyer.
Yeah.
We got deep pockets. We got insurance for that sort of shit. But the idea that I negotiate a contract that's meaningless almost, that the court's going to allow my former partner to basically extort me using the legal process is really, really unfortunate, but that's the reality. So you should know when you do these agreements, what you're doing is reducing the probability of an argument. But even if you do get an argument, you're putting yourself in a better position because you've still got the leverage.
Yeah, exactly.
Right? The odds are still in your favor, even if they're not 99%, even if they're
That's right.
80%. But
and it's not that it's not. I mean, yeah, okay. There's odds in your favor, but there's also, well, how much would you what's going to happen, right? And when you use a 50 million, 25 million, 3 million example, it's like, oh, okay, those numbers make sense. I get that. Yeah.
so
Okay, so what about? And maybe we talk about this next time because maybe we're running out of time. But what about Section 8? What about these factors about not sharing equally? That's interesting. People always forget that. People don't talk about it. Sometimes lawyers don't talk about it.
Yeah, and the problem is, I don't know if you've looked at that recently, but there's no consistency in the courts in how they apply Section 8. So Section 8 is when you don't have assets that are presumptively equal. So for example, increased value of exempt assets. They're not presumptively equal.
Right.
And so you look at various factors under Section 8 of the Act, and, but is it going to be 40%, 30%, 50%? Who knows? Roll a dice.
Yeah, right.
Roll a dice.
Yeah.
In some respects, I don't know. Are you the husband or the wife? That makes a difference.
Right. Yeah, it does. Yeah.
Anyone who says it isn't, they're not being honest.
Family farm, I'm pushing 46%, but.
And it used to be, the courts understood, well, look, the dirt went up in value that he owned the day you got married. You didn't make it go up in value. So why should you give 50%?
Yeah. How about an RRSP, the growth on an RRSP that's individually owned, not contributed to during the relationship?
Right. But, you're in my experience, you're still looking at 40% on a best day. Unless there's something really sort of despicable about your spouse.
Right. Okay.
First of all, are they a man? If they're a man, you're closer to the 40%. If they're a despicable man, maybe 30%, maybe less, depending on how shitty they are, right? So there's some factors, but very hard to predict what the distribution of future value or increased value on an exempt asset is going to be. More often than not, it's going to look something like 50%.
Yeah.
But not necessarily. I negotiated a farm agreement not too long ago. We're just finalizing it now, where we ended up at about 40-45%. And to me, reasonable enough.
Yeah.
Could have been worse.
Totally.
So that's our spiel today. And unlike most days, this is not a Friday. So we're still working. I'm in what's called a judicial dispute resolution tomorrow morning. Justice Nixon, I think.
Okay, yeah.
So it should be interesting with Aaron Reinhart. No idea what's going to happen. Just a bizarre.
I like Aaron. I hope Aaron listens. I like Aaron. He's a little different. He is a little to himself. I don't know. I like him. He's a great guy. Yeah.
Don't like him too much.
I'll try not to. I like everybody though.
Yeah, so we'll see what happens. We're doing a Zoom JDR. I'm not sure how that's going to work out.
That's cool.
I bought an extension cord for my camera so I can mount it on the TV in my office. We'll see how that works out.
All right.
If it works out, maybe we'll do a podcast in the same office sometime.
That'd be fun. Yeah, that'd be cool.
So we yell at each
other. Yeah, sure. I've got provincial court tomorrow morning. I very rarely end up in provincial court, but I'm in provincial court tomorrow morning. I think they're going to phone me on my cell phone. They know my cell phone number.
For what?
I need to adjourn something.
Why can't you just call it in, Tyler?
I did, so I phoned, and they said, no, you got to show up.
I know, right?
Well, we got to phone you in the morning. You got to tell the judge. The provincial court's a court of record. You can't just do something. You got to make sure there's a judge in a courtroom.
Queen's Bench. Last week, I had an application Tuesday. Friday, we resolved it. Settled. Call the clerk. Say, we got this application coming on Tuesday. Everybody's good. You can take it off the list. Nope. So 3 lawyers, one in Lethbridge, one in
Oh
Edmonton,
no.
or 2 in
Yeah.
Lethbridge, one in Edmonton.
Yeah.
We have to dial in 15 minutes early, right?
Yeah, you do. Yeah.
So you sit
I
here,
did it this morning.
you know,
Yeah, I
on
did
your,
it this
on
morning.
your on your Zoom or your WebEx,
Yeah, I told some jokes.
and then it takes them a little while to sort of coordinate everything. So you're kind of hemming and hawing, and a bunch of pictures all over the screen of your fellow lawyers, and then it gets called up. The matter of so and so and so and so, Mr. Harvey. Yes, sir. It's resolved. Can come off the list. Okay, thank you. Explain to me why that couldn't just happen. Explain to me why 3 lawyers bill their clients $500 an hour for 20 minutes to half an hour instead of being able
You
to phone
stop
that in.
hijacking our topic. That's not our topic today.
But it just never ends. But anyway,
All right.
I leave that. So have a good time and you're on Zoom tomorrow in provincial court.
No, they just phoned my cell phone. They just want to chat.
Oh, okay. Well, that's better than Zoom, I guess. So
Yeah, I'm
talk
going
to
to go
them.
out and hang out with my son and walk around the neighborhood, and I'll just take the calls in.
And I will be doing my JDR in the morning.
Enjoy.
And hopefully our clients can find resolution. Otherwise, we'll go into trial, which be an expensive proposition. But anyway, we'll see what happens. So have a good evening.
You too.
And again, questions, comments, put it on the bottom right there on the YouTube. Email them to us. Nobody has. We're offering free legal advice. My billing rate's $500 an hour. I will respond to you for nothing. And nobody takes advantage of it. It's hilarious. Anyway, and Tyler. All
I'm
right.
smarter than that guy. Might as well.
Better looking anyway.
That was something. I can't remember.
All right.
Bye, everybody.
Ciao.